rise. Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. This is case number SA18-0101 and the matter of Melania Lokosky versus Russell Ruffino. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs and have conferenced the case. Counsel, you may proceed.
May it please the court. Nathaniel Hill for petitioner Melania Lokosky. With me is Jennifer Ooms, who is a legal assistant who will be helping me today. I would like to reserve 6 minutes for rebuttal. I'll try to watch the clock on that regard. As a constitutional issue of first impression in Arizona, at least to these specifics, we would urge the court to take special action jurisdiction here. This is a matter of statewide importance that is likely to arise again in the future. In the age of the internet, the propriety of an injunction against posting information on the internet regarding another individual or an opposing party in litigation is a question that should be answered. Special action jurisdiction should also be presented here because it is a matter that's purely legal in nature. The propriety of whether or not to keep the injunction in place is a legal question. And finally, petitioner does not have any equally plain, speedy, or adequate remedy by appeal. In fact, she tried other alternatives to getting relief for this, and those were not shown to be viable alternatives. So we would urge the court to accept special action jurisdiction here. One comment on that special action is that jurisdiction is that the only basis that respondents have raised as to oppose jurisdiction is an argument regarding latches. However, respondents have not even presented an argument as to how they were harmed or prejudiced by the alleged delay. We would submit that there was no delay based on the order from which the petition is taken was filed in March 20th of this year, and then the special action was submitted later in April. So the delay argued by respondents simply doesn't exist. On the relief sought by petitioner, the trial court had a duty to ensure that the injunction did not violate her free speech rights. It was an abuse of discretion and legal error to permit the continuation of an invalid restraint on speech because the injunction violates Ms. Lokosky's speech. It's invalid and it needs to be resolved immediately. I think the key here in preparing for oral argument today, I think that we can zero in on the Arizona Constitution. I think the Arizona Constitution is what answers the question for us today. And the reason is that Article 2, Section 6 of the Arizona Constitution clearly states that every person may freely speak, write, and publish on all subjects, being responsible for the abuse of that right. I would underscore every person. It doesn't matter who you are. You have a right to speak, publish, and communicate in Arizona under the Arizona Constitution.
Well, that's not absolute, though, counsel, is it?
Well, there are restraints, and it can be restrained.
When can it? In what circumstances can it be restrained then?
Well, there are several lines of Arizona cases that give different tests for when those restraints can be in place.
Did Judge Goss engage in any of those tests?
None of those, Your Honor. And therein lies the problem, right? One. Since you asked, one way is the test under the Salib v. City of Mesa case, right? Those are the four factors where it's got to be content neutral, it's got to protect a significant government interest, it's got to leave open ample alternative channels for communication, and it's got to be drawn with narrow specificity so as to affect as little as possible the ability of the sender and receiver to communicate, right? So in the Salib Mesa case, that was where there was a city ordinance that prevented more than 30% of window marketing in a commercial window, right? So you're right, there is a circumstance where it was held to be a valid restraint on speech so long as it met these parameters. But the court analyzed those factors and found that those factors were satisfied in order to allow the restraint on speech. That test, as applied to this case, would fail on all four factors. It's not content specific. It's not content neutral, which is what the test requires. It's content specific. Petitioners only enjoined from publishing anything about respondents or their attorneys.
And I think the difference between the two cases is that is a state actor acting against private individuals. What we have here is a court saying, you guys go back to your corners, let's wait, and let's get this working through the system. Let's get to the merits of the case, and let's just maintain the status quo, which courts are entitled to do. So how does it being private actors differ in your analysis?
Well, it's the court is a government actor who is the one making that requirement and issuing the restraint on speech. And moreover, the way that the injunction is set up, it's a prior restraint on speech, which is subject to a different test than the example that I gave. So in answering Judge Bean's question of can speech ever be enjoined, I was giving an example of a circumstance where it can. To the extent that analysis would be applied to this case, it would fail. The prior restraint analysis is under a different test. Judge Cruz was recently on a panel of a case. It was Phoenix Newspapers versus Otis, and where that three-part test was analyzed here. It was the same where it was the court that was the entity restraining the speech. So I don't think that the fact that they're trying to send private parties back to their corners is germane to the analysis, with all due respect, because I see it as because the court is the one who's requiring the restraint, it's still the government actor who's doing that. Now, under that case, and regretfully, that case was not cited in the briefing. I found it after the fact, but it applies the analysis of three critical parts. One, the nature and extent of the harm sought to be avoided. Two, whether measures short of a prior restraint would adequately protect against the harm. And three, how effectively the restraint would operate to prevent against the threat and harm. None of those factors apply in this case either. Now, going back to the Otis case.
Now, the court in this case did not engage in that analysis, correct?
Correct. The court did not engage in any analysis.
So tell us why we should not remand so that the court can engage in that analysis.
The reason is because under the circumstances, the prayer for relief as raised by the respondents, who were the plaintiffs in this case, they sought to enjoin a libel, right? And this is what we heavily briefed in our cases, is that equity cannot enjoin a libel, right? And so until there is a judicial determination that the speech at issue is false or not eligible for First Amendment protection, then there cannot be a restraint on that speech.
Well, but we just talked about the Phoenix Newspapers case and the three-part test that was laid out. Why should the judge in this case at the Superior Court level not engage in that analysis and determining whether or not the parties should be enjoined from speaking? Okay.
The reason is because I still think it's because the complaint at issue is because there's not been a finding that the speech to be enjoined was false. And so to remand it to go have that analysis is to really to go remand it and go conduct litigation, right? That's to go get us in front of a jury. And so the remand wouldn't be to go do the analysis. The remand is, well, go remand and go engage in litigation from the beginning of the case and up and until a fact finder can decide that the speech at issue is in fact false. Comparing it to the Phoenix News Otis case, I don't believe that that would be effective, because you can see from where we sit now that none of those factors would be or can be present, mainly because of the nature of it being a prior restraint. And that's why well,
that was the case in Phoenix newspaper.
Well, but it was a different situation, right? In Phoenix newspaper, as I recall, there was a prosecutor who was a victim of stalking, and so there were safety issues needing to be addressed. There were jurors who were concerned about retribution, depending on how they might respond in the situation, so they didn't want it published. And then the main reason is that even those same factors, that other case is still in the public domain, right? And so one of the key factors is what good would it do? And so as I look at that, I don't see any of those factors, how they could possibly even be in place. Even if the case court was to remand it to go have that analysis, the injunction should be dissolved immediately and not reinitiated up and until those factors are established. And so I think the key here to look at is that we have an invalid restraint on speech, a restraint on speech that by its nature would only be in place had there been, in fact, been a judicial determination that the comments allegedly made by petitioner were false, right? Starting this, if we were to look at this as if a lawsuit was filed from the very beginning and bypassing kind of all of the default judgment stuff that happened in between, they would not get that injunction. It wouldn't happen. No court would issue an injunction for a plaintiff who filed a complaint, made an allegation of a false statement, and then they automatically get an injunction enjoining any speech against that. They would never get that. The threshold for free speech is too high, and they could never make that showing, even if that analysis was performed by the trial court. And so I think that where we're stuck is we're trying to work backwards from there, right? An injunction was issued. Now remember where we started with this. There was a default judgment. Petitioner made an appearance to get property back that was improperly taken. At the time, there was a valid default judgment. That is what enabled the court to justify having the restraint in the first place. As soon as that default judgment was vacated, everything connected to that default judgment, including a finding that the speech at issue was false to support the injunction, should have all gone away. And so because we're working backwards to say, well, can't we just do the Phoenix News Otis analysis? I see your question, but I can't think of what university you would get that if you were just a normal plaintiff who filed a complaint against a defendant and then you applied for an immediate injunction without being able to prove the falsity of the statement at issue, which is my point I said earlier. That's really that's the entire litigation. And so you'd have to wait for a fact finder to make that ultimate decision and ultimate question. And so here, I don't think that would be an appropriate analysis to make. Even if we were to do that Otis analysis, on the first prong of that, the nature and extent of the harm, in the Otis case, the nature and extent of the harm was too speculative. It would be too speculative here to say, well, what's the harm of what may or may not be posted on the internet? We have no idea, right? And the second prong is what measures short. Just
a moment. We have no idea of what the harm of the comments in your client's website, what harm she's causing to the opposing party?
Well, there's going to be an allegation that harms my reputation, but to what extent? What does that mean? I think we need to back up a second and look at the fact that just because you say something that's negative or embarrassing or offensive to someone doesn't make it libelous. It doesn't make it speech that you can't put out on the internet, right? And unflattering words don't mean that you get to run to a court and get somebody to stop saying it, right? So when I say too speculative, what I mean is someone may put something on the internet. They may say, well, that harmed my reputation. Well, to what extent did it harm your reputation? How are you?
Isn't that the premise of your client's business? Putting things out on the internet that will hopefully cause business to decline or effectively take somebody out of business?
No. I would adamantly disagree that that's the purpose. The purpose of her business is to shine a light on corruption, abuse, and those things. And so she's not
Because
trying.
words have an effect.
Well, so does every news media in Western civilization that's ever been there to present on the effect of government. The freedom of publication and the freedom of the press is a sacred right in Western civilization, and that's why we have this First Amendment right, because shining a light on these things stops it from happening. So just because that's going to stop it from happening or cause some sort of concern or potential embarrassment doesn't mean that the court can enjoin it.
Right, and you're correct in that, but my point is that you indicated earlier that it's speculative to say that it may have any impact, or that it may have any impact when that's actually the purpose of it, to have an impact based, granted, on your client's position that it's truthful speech.
Right, and I guess that's where the law has developed to where defamation you have a remedy for damages, right? You can take that claim and you can go prove damages, but what the extent of those damages are, who knows whether or not it was even defamatory or unprotected speech under I'm not going to get into the defamation elements and defenses, but where that lies, when we're in the position from a prior restraint and we're looking down the road, we know what the roadmap of litigation looks like, but where that's going to land from at the position of a prior restraint, that's why I'm saying that's too speculative. That's so far down the road, we have no idea what it is. We can say, well, that may or may not cause some harm or embarrassment, but because there's no specificity to it, going back to the Otis case, the harm concerned about was the prosecutor had a stalker, right? That's a real immediate harm, and the concern was to stop that. And as I recall, the court still didn't. The victim in the Otis case was a prosecutor who had a stalker following her. Is that right?
Oh, I remember the
Anyway,
case.
I'm sorry. I just...
Actually, the concern was that the jury would find out about the prosecutor and separate proceedings that were occurring.
Okay, well, but the ultimate issue is a concern for personal safety.
Well, there was a concern that separate proceeding might inform the proceeding that was happening in the case the prosecutor was actively prosecuting. That the fact that she was a victim in some other case would inject itself in these proceedings and affect the ultimate deliberation against a separate defendant who had nothing to do with that case.
And thank you for that clarification. I've read a lot of cases in the last few hours, 24 hours. So
I bet.
The point is that there was a real, immediate, and identifiable harm. That's the distinction I'm trying to draw there.
And counsel, you keep saying look down the road. You're not saying that your client's speech, whatever she would choose to engage in, may or may not ultimately be determined to be libelous. You're saying to her own peril, she will continue to do what she wants and speak the way she wants to. And if it is libel, we'll deal with it down the road. But you can't enjoin her from speaking at this point.
That's the point, and that's what the Arizona Constitution says. It is the last clause of Article 2, Section 6 is
To your own peril, I believe.
well, it's not that's not the exact wording, but for the responsible for the abuse of that right is I think how. So that's the same point. So yes, but to enjoin that now, it's too premature. I see that my time is nearly spent. I would, unless there's any immediate question, I will reserve the remainder of my time for rebuttal.
Sure.
Thank you, Your Honors. May it please the Court. My name is Dan Warner. I'm here on behalf of the respondents, Russell Ruffino and Clients on Demand. I don't have too much to add to my brief. I think it's pretty detailed, and I think it covers a lot of the points we've been discussing here today. So what I like to do is just kind of go through and hit some of the high points and highlight some of the particular facts in this case that really, I think, resolve the issue. You know, the parties here are competitors. This is a basically a false advertising case in many respects. And the defendant, and I think Your Honor said it fairly well, her business is to basically call people frauds and to make money off that, or hope to make money off that. That's her business. And that's what she did to my clients. And that's what she wants to continue to do while the parties are in litigation. And she's actually said that in pleadings. She said that there's no universe, and I'm probably, not quoting it exactly, but she said there's no universe that it will not be talking about how Russell Ruffino was a fraud or something like that. So it's her intent to do that. And that is actually one of the issues in the case. That's one of the statements at issue in the case.
Doesn't she have the right to say that until it's determined that it's not a true statement, in which case then she can be enjoined from continuing to make it?
Well, Your Honor, in that you're kind of shortcutting where I was going with that, and I appreciate that, and so I will kind of cut to the chase there. Basically, there was I guess collectively a 3-day evidentiary hearing on many of these issues, and if we look at the context of the
evidentiary hearing wasn't primarily on this issue. It was on issues of the judgment that was entered that took away the website and gave it to petitioners, or I'm sorry, to your clients.
That's correct, Your Honor, but also a significant portion of that hearing was dedicated to determining whether there was a meritorious defense. And my client presented a bunch of evidence with regard to proving the falsity of the statements. And that evidence was never controverted. In fact, to this day, the defendant still has not attempted to controvert any of that evidence. And the court throughout the evidentiary hearings gradually continued the injunction, which the defendant actually agreed to. And she agreed to it multiple times, not just once. And let me just talk about that for a minute. So the initial TRO, she agreed to that.
Now, did she agree or did she acquiesce?
She agreed to it, and I would direct the court's attention to the January hearing transcript where she acknowledges that she agreed to remove the content and be enjoined.
And that was before the default was set aside, correct?
That is correct.
Okay, so is there any reference to an agreement after the default was set aside?
I don't believe there was after. There was another instance where she actually presented evidence to the court and essentially asked that the injunction be extended or be made mutual, and the court did that. And from that point, the court found, and this is reflected in the record in the transcript from the hearing, that if the court did not continue the injunction, even though the ruling went as it did, and he set aside the default judgment, that basically we would be here forever. And I think he said we'd all have issues. I forget his wording. And he didn't make a specific finding, but if you kind of look at the language, all of those elements are there.
When was the first time she objected?
The first time she objected was not until, I believe, June.
Procedurally in the case.
That's correct.
When was the first time? At what point in time?
That was, I believe, a few months after the motion or the default judgment was set aside. And also, too, it's important to note that the injunction it doesn't restrain her from discussing these issues. It specifically deals with posting on the internet, because it's established and it hasn't been controverted that she wants to basically go for her business, post this information on the internet to try to make money off it. At this
How
point,
does that make a difference in our analysis then?
because it's commercial speech, Your Honor.
Did you brief any type of commercial speech analysis?
I believe I did. I believe it's in there. It's not like, and just comparatively, it's not like the defendant is a journalist. You know, she's a competitor. And that, if we look at the case law, that makes a significant difference, I believe.
You keep saying she's a competitor, and I'm a little bit, how is she in direct competition with your client?
Thank you for asking that, Your Honor. She is actually, they are both in the marketing coach industry. They're both essentially marketing consultants, so they're vying for the same clientele. And there's a significant overlap there.
How is she a marketing consultant? I'm confused.
I believe that's explained in the record, and she acknowledges that as well. She advertises that she teaches people how to market, which is exactly what my client does.
Through the website, or is the website separate?
It's advertising, Your Honor.
Okay.
So everything she posts on, and this is actually in the transcript, she admits this, everything she posts on her website, on Twitter, on Facebook, it's all for the purpose of marketing and driving potential customers to her business, to get business.
I guess I'm just missing the nuance here. Your client is a marketing consultant. She's trying to generate revenue from a website through the selling of advertising. Not however the internet stuff works, where you get hits and you get money, and I don't know how that goes, but I'm a little confused.
Right, so she's promoting, she does what my client does. She teaches businesses how to market themselves successfully, right? She uses these websites and everything to get clientele, basically to solicit business, much like my client does. My client posts stuff on Twitter to get clients in the door. She does the same thing. She goes about it a little bit differently. She doesn't pay for advertising like my client does. Instead, she sabotages people, calls them frauds, and basically leeches off their name and reputation to direct and divert business from that person to her.
Okay, so let me just make sure I understand. Your client sells marketing consulting and teaches people how to market their products and get clients. She basically disparages businesses or whistleblows in her content of how she sees her own business model, right? So when I see you in direct competition, nobody's going to go to her that would come to you, because what you're selling is not the same.
I think, Your Honor, I think you're kind of, and maybe I'm explaining it poorly, but they do the same thing. I understand that there's a whole whistleblower type of persona that's being used, but the bottom line is, and this is reflected in the record, she does the same thing my client does. She's not just a whistleblower. She wants to teach people, and she tries to get clients to teach them how to do marketing, how to successfully market themselves, which is exactly what my client does. She just goes about it very, very differently.
In your answering brief at page 27, you quote defendant as stating, quote, all of my business efforts direct clients and customers to view my website. The longer the website is not operational, the more I lose business. And so, close quote. So she's referring there to clients and customers.
Correct.
And what do you make of that in terms of what's the difference?
So what she's saying is, the longer her website is down, the less likelihood she has of soliciting potential business. Just like if my client couldn't post on Twitter, he happens to get a lot of clients from publishing on Twitter and soliciting people that need his services. The same thing with her. She's saying that if she was precluded from, if her website wasn't functional, then she would lose that same ability.
Mr. Warner, my understanding of this area in that temporary restraining orders enjoining future speech can only be issued after a court determines whether such future speech falls outside of the protection of the First Amendment. So where did the court make the finding in this case that I feel case law dictates that Judge Goss had to make? Where was that finding in the record?
Your Honor, the finding in the record was towards the end of the two-day evidentiary hearing on the defendant's motion to set aside the default judgment. The trial court acknowledges that the defendant has a very uphill climb, essentially, and he kind of goes into another, starts talking about something differently, but that essentially is a finding. And what's more, I guess, the issue. He found
that any future speech that Ms. Lokosky made fell outside the protection of the First Amendment.
Well, that's I don't think that's necessarily accurate. I think what he found was that if she were to post anything about the case, it would be number one, to call my client a fraud, which she put forth no evidence or controverting facts to establish that, and my client demonstrated that it was false, and that she would do that for the sake of proliferating her own business, her own competitive advantage.
Counsel, in your answering brief, you set out the test cited in Show and Be Shown, 167 Arizona 58, and you state that a party seeking an injunction traditionally must establish 4 criteria, beginning with the strong likelihood of success on the merits, followed by the possibility of irreparable injury if the requested relief is not granted. Third, a balance of hardships favoring that party, and fourth, public policy favoring a grant of the injunction. And so my question is, the court clearly in this case did not engage in this analysis before entering its restraining order, correct?
That is correct, Your Honor. And I believe it's because of just how everything transpired. The circumstances are unique here because we have a situation in which the defendant agreed to the injunction multiple times, and then all of a sudden it was, well, we have 2 injunctions here. And I think this is important to note too.
Let's stop for a moment. You agree that this is the test that must be applied, and for the reasons you want to get into now, that analysis was not done, but the result is that we have this restraint, this temporary restraining order, this injunction. So, which she does not agree to. And when we say agree, I mean, that's very loosely used. There was not a stipulation of the parties that you're both going to abide, knowingly, intelligently, involuntarily entered into it. It seems to me that it was more the judge said, this is what's going to happen, and the parties said, yes, Judge. And one of them then ran to the Court of Appeals and said, we don't want that to happen anymore. I mean, when we say agreement, it's kind of hard to find that there's an agreement of the parties willingly entered into. So no agreement, and then no analysis and no findings from the Superior Court, right?
Well, and I think there's a discrepancy with that because we have the initial temporary restraining order was actually drafted by the defendant. Her language with regard to the restraint. the judge did not draft that language. And then she continually agreed to it, and then she actually essentially asked the court to extend it and make it mutual. And she didn't complain there. She essentially asked the court to make it mutual. So
That was all while there was a valid default judgment against her, though, correct?
that is, and thank you for asking that, Your Honor, because the injunction from the default judgment was basically treated as it wasn't even in existence. And this is demonstrated when you look at the record, because the defendant, she violated whatever injunction we want to look at, whether it's the default judgment injunction or the subsequent injunction. She violated. She stated on the stand that she wasn't considering that a valid court order. She stated that. Then on top of it, they filed after a very long time, they filed a motion to, I think, modify that previously. Actually, no, I'm getting that wrong. They filed something, and it's slipping my head right now, but they filed something to basically acknowledge that there was technically an injunction there from the default judgment, even though the defendant continuously said, I'm not recognizing this as a valid court order. So because you have her saying that that's not a valid court order, but yet on the other hand, she's going and she's asking the court to make this other injunction mutual, she did in fact agree and acquiesce to it.
So when she initially offered the language and says, Judge, return the website to me, it's my website, return it to me, and I'm not going to post anything against the other party, essentially is what the language would result in, correct?
That's correct.
And she's asking for her property, a website, to be returned to her, which had been given away to your clients by virtue of default, correct? Default judgment.
Yeah, that's.
Which had not been initially requested, correct?
I'm not sure I understand your question.
Possession of the website was not initially requested. It's something that happened when you went back to obtain default judgment against her, correct?
When you say initially requested, you mean?
In the lawsuit, when you filed the complaint.
Was it specifically requested like a replevin type of cause of action?
Anyway, was
Well,
that
there
a
was-
prayer for relief?
There was cause of action or injunctive relief sought, which, as we know, equity it molds to kind of deal with the situation as it needs to.
Well, and as we know with defaults, you file, and if the other party defaults, you get what you asked for initially, not, and let's also take possession of the website, correct?
That's correct, Your Honor.
So that
but-
was an overreach, which she sought to have corrected when she went back and said, for now, give me back my website, and I promise I'm not going to put anything on there about the opposing party, but you weren't entitled to have the website in the first place.
I disagree, Your Honor, respectfully.
Okay, tell me why.
I disagree with that because in the complaint, it basically asks for any remedy that would be required to correct the harm, the continuing harm, the ongoing harm, the irreparable harm, et cetera. And that was made clear in the default judgment itself because it essentially, as a last resort, that would be the step to be taken. Because we first attempted to avoid that, use the, I guess, least intrusive method possible, but then when that was no longer successful, we had to resort to the next step, which was basically executing on the judgment and taking ownership of the website.
But at no point did you give her specific notice that taking ownership of the website is something you were going to request of the court?
Well, she did not. That's because she evaded service with her mother, with the
Well,
help
and
of
then
her
you
mother.
served her by publication in Hilla Bend, which makes no sense, but that's a separate case. But, all right,
Okay.
thank you, counsel, your time's up.
Yep, you're welcome.
Forgive me if I move fast, the time is short.
Please do.
They are not competitors. There was only an allegation that they were competitors, and in my belief, so as to bootstrap a line of cases that allow injunctions in speech against competitors. There's no way in which they're competitors.
What does your client sell?
She has not made any money on her website.
But how does she hope to make money off of her website?
There is a consulting service that she would ultimately offer that's not connected to her website. It's a different website. So she has two websites, killingmycareer.com, which is where it's more of a news publication where she's shining a light on fraud and abuse. And she has a separate website called MMPIHER, and I believe it's pronounced Empire. Now, there is cross-reference between the two, but one is not marketing for the other.
What type of cross-reference?
Well, like on the Killing My Career website, it might say, to learn more about these things, go see this other website.
And that other website is the same type of business?
Not even close, not even close. They mass market to anybody on the internet who wants to become a better coach. My client is an individual, one-on-one consultant, one at a time kind of a thing.
Consulting for what?
How to improve business processes and those.
And marketing?
I mean, if that was under the umbrella of improving business.
Well, I mean, business can be improved by cleaning a business, right? If you have
Right.
a clean restroom and clean facilities, it'll improve the business.
Right, and if
but
she-
she's not selling that.
Well, she's off. What she's trying to offer is a way of identifying individuals who engage in fraud and abuse, and how to not have those people working for you
Okay,
and your
that's
company.
Killing My Career. But the other website that she has attached to it does some things that are similar to what her opponent in this case does, right?
It's a semantic similarity by saying consulting is a similarity. I counsel people as an attorney, and so does a psychologist counsels people, but we are not competitors. They're worlds apart.
All right. Thank you, counsel. I see your time is up.
Can I make one last?
Go ahead.
I
Go
wanted
ahead.
to. I guess just since so much time was spent on the agreement, there was never an agreement. I want to clarify the timing of it. Judge Goss had a telephonic hearing where he instructed plaintiffs at the time to draft that agreement, and because they took too long to do it, we took the initiative and we drafted it pursuant to Judge Goss's directions on the language to use. So the language
That's on
that
the
there
record.
is Judge
Right.
Goss's language. So.
And that is on the record. We're aware of that. Counsel, the matter is now taken under advisement. We will issue a written order in due course. We're at recess. Thank you.
Thank you.